Spending Federal Money, Part 2.
Rule number 5, spend the money only for bona fide needs of the time period provided. Rule number 4 limits the amount of time we have to spend federal funding. Rule number 5 adds a bit more complexity. This rule number 5 is part of the time requirement that was enacted in 1870. It tells us that we have to spend our money only for expenses properly incurred during the time period it was appropriated for. There's a nice Latin term for these legitimate needs: bona fide needs. The bona fide needs rule complements rule number 4 regarding time. It would not make sense for Congress to restrict obligations to a particular time period if federal agencies could obligate funds for expenses for a different time period. The bona fide need rule ties together the principles of purpose or need and time. What does this mean to us? Well, it means that you can only obligate current year appropriations for legitimate or bona fide needs that arise in the current year. You can't spend any current year funds on last year's needs or next year's needs. Note that this principle applies only to appropriations with fixed periods of availability and therefore does not apply to no-year appropriations. Since no-year appropriations have no limit on the time period for obligation, the issue of applying a bona fide need test becomes moot. So, let's assume we have FY 2014 money, here designated as blue. We know this blue money can only be used for a bona fide need of fiscal year 2014. If the obligation, performance, or delivery and use takes place during this same fiscal year, the application of the bona fide need rule is a piece of cake. But this circumstance is rare. Let's consider 3 general types of spending: supplies, services, and grants, to get an idea of how this rule is applied. As long as you purchase supplies and use them in the same fiscal year, there's no bona fide need issue with our blue money. But what if, as you approach the end of a fiscal year, you decide to spend some of your funds for supplies that clearly will not be used or even received during the current fiscal year? Is this okay? With the purchase of supplies, there are a couple of exceptions that would make this type of purchase permissible. If you need the supplies now, and it takes a while to receive an order, it would be permissible to spend your current year funds and receive the supplies in a subsequent fiscal year. This is known as a lead time exception to the bona fide needs rule. Of course, the lead time should not be excessive, and the supplies should not be readily available somewhere else. Suppose you purchase supplies at the very end of the year that won't be used until the next year. If you're maintaining a particular inventory level to avoid any disruptions of operations, a bona fide need issue may not arise as long as the amount is reasonable. But as you can see, these situations are open to interpretation, and you should always consult with your general counsel if there's any doubt. Like supplies, any services paid for and used within a fiscal year do not raise bona fide need issues. However, services that cross fiscal years have to be analyzed to make sure they don't break this rule of appropriations law. In order to do that, we have to consider whether the service is non-severable or severable. Non-severable services are a single undertaking that cannot be feasibly separated or severed into continuing or recurring services. A good example of a non-severable service is a research project that culminates in a final report. Given that it may take several years to gather sufficient research to produce a final report, a non-severable service may span more than one fiscal year. The Bonafide need rule requires that there be a need in the fiscal year of funding, and the Adequacy of Appropriations Act that we were introduced to in Rule number 3 requires that you fully fund the service from funds available in that year. It is therefore not permissible to incrementally fund a 3-year non-severable service from fiscal 2014 funds, fiscal 2015 funds, and fiscal year 2016 funds. Note that the 3-year non-severable period may start midway through the year, or even late in the year. The important thing to remember is that the project must be completely funded from the blue appropriations available in the year the bona fide need is met. Severable services are services that continue, such as window cleaning, computer support, or security services. More importantly, if you have to stop or sever the service, you still have something to show for the obligation, like clean windows, for example. These types of services lend themselves to obligation for 1 year at a time. So obligations should cover the period of availability of the funding appropriation, generally 1 year. Here we can see the blue money for fiscal year 2014 services, green money for fiscal year 2015 services, and orange money for fiscal year 2016 services. Based on the Federal Acquisition Streamlining Act of 1994, these types of obligations are permitted to span 2 fiscal years, as long as the basic obligation does not exceed 1 year. If the bona fide need for the service continues into the next fiscal year, an obligation may be made from that year's appropriation to extend the service for another year. Note that in both types of services, non-severable and severable, you are fully funding the service from funds currently available to you. This is required by the Adequacy of Appropriations Act. You may not forward fund a severable service, that is, use current resources to fund a service for more time than the period of availability of your resource. This would violate the bona fide need rule. With grants, the application of the bona fide need rule is much simpler. The previous examples primarily relate to contracts, which provide goods and services. Grants provide financial assistance, not goods and services. This basic difference means that the application of the bona fide need rule for grants is simply a matter of determining whether the obligation was made during the period of availability and whether the grant was for an authorized purpose. Grants can occur at any time during the fiscal year, since severability is irrelevant to a bona fide need determination. There are a couple of other situations in which the bona fide need rule applies as well. The bona fide need rule must also be applied to adjustments or modifications to obligations. Let's suppose we are now in fiscal year 2015 and we need to modify a contract that was awarded in 2014 with blue money. If the changes or modifications are within the scope of the original award, we call these antecedent liabilities, then we must fund these modifications with blue money. That is, the appropriation available at the time of the original obligation. However, if the modification exceeds the general scope of the original contract, for example, by increasing the quantity of items to be delivered, the modification amounts to a new obligation and is chargeable to funds current at the time the modification is made. That is green money if we are in fiscal year 2015. It is possible to issue replacement obligations, contracts, and grants in cases where the original obligation had to be canceled. In these cases, it's important to remember that the replacing obligation has to meet the same bona fide need as the original. It can't exceed the original scope, and it has to be awarded within a reasonable time. In summary so far, the first 5 rules establish that Congress makes the rules. These rules relate to purpose, amount, time, and bona fide need. Rule number 6, make the money last until the next appropriation. So we know we have to spend for a purpose, within an amount, and within a period of time. So how do we make this happen? How do we make the funds last? And why is it important to make the funds last? Well, it all goes back to the congressional power of the purse. Congress appropriates funds for a period of time and does not want federal agencies to spend all their funds and then come back for more before that period of time is over. Less than 10 years after passage of the Anti-Deficiency Act, the post office tried that tactic by using up all their money and suggesting that the mail would not be delivered without more appropriations. This is called a coercive deficiency. That is, spending all your money in order to coerce or force Congress to appropriate more. Needless to say, this did not make Congress happy. They do not like to be forced to appropriate money. So, in 1905, they amended the Anti-Deficiency Act to require an apportionment process that would prevent undue expenditures in one portion of the year that may require deficiency or additional appropriations to complete the service of the fiscal year. Rule number 6 requires us to make our funds last for the whole period of time for which they are made available. This 1905 amendment to the Anti-Deficiency Act has been codified at 31 U.S.C. 1512 and requires that funds shall be apportioned to prevent obligation or expenditure at a rate that would indicate a necessity for a deficiency or supplemental appropriation for the period. This is just another way of saying we have to make the funds last. Congress tasked the President through OMB with the responsibility of making sure funds last and agencies don't spend all of their money before the time period has ended. In order to make sure, OMB apportions funds by time periods, usually quarters, or by particular activities, or a combination of both. Let's take a look at an example. Suppose we have an appropriation for good government that says, for carrying out Title I of the Good Government Act, $100,000, provided that not to exceed $5,000 is available for administrative expenses. Note how Congress establishes purpose, amount, and if we recall the rule on default period of availability in an Appropriations Act, we know these funds are available for only 1 year. Let's further suppose that Congress provides more detail on purpose in a conference table. OMB's apportionment might look like this. Note how the appropriated amounts are reflected on the apportionment. The $5,000 in administrative expenses is split into 4 quarterly amounts in Category A. This ensures that the administrative expenses last the entire year. The grant programs, both formula and discretionary, are shown apportioned in Category B as separate programs. Since obligations cannot exceed these amounts, this ensures that funds will last the year. Once OMB has signed the apportionment, the agency institutes an administrative control of funds process to ensure the amounts apportioned by OMB are adhered to. This process, required by the Anti-Deficiency Act, requires that agencies prescribe by regulation a system of administrative control that restricts obligations to amounts apportioned and enables the head of the agency to fix responsibility if an apportionment is exceeded. To ensure that agencies control amounts apportioned, the Anti-Deficiency Act prohibits obligations in excess of apportionments and amounts permitted by these regulations. We call these amounts allotments. In the 1950 amendments to the Anti-Deficiency Act, Congress made exceeding the apportionment or the allotment a violation of the Act. So let's add 2 new rules. Rule 6A, spending must not exceed the apportionment. Rule 6B, spending must not exceed the allotment. In order to make sure that each of the amounts is not exceeded, the administrative control of funds process uses a hierarchical structure to make sure the funds are properly controlled. Let's walk through that process. Each apportionment control requires at least 1 allotment. Our sample apportionment requires 3, 1 for administrative costs, 1 for formula grants, and 1 for discretionary grants. Allotments are generally issued by the Budget Office to the offices responsible for managing the funds, referred to as the allottees. These offices then issue allowances. In our fictitious example, the administrative costs are distributed by allowance to the offices responsible for salaries and expenses and contracts. The formula grants are distributed by allowance to the social services and education offices, and the discretionary grants are distributed by allowance to the training and technical assistance offices. When we look back at the conference table, we can see why the grants are distributed the way they are. Our fund control mechanisms are designed and implemented to ensure that funds are spent for the purposes they were appropriated. Once the funds have been apportioned, allotted, and allowed, they're ready to be obligated. When everybody follows their responsibilities, funds are spent in such a way that a program does not run out of money before the fiscal year is over, and the Anti-Deficiency Act is not violated by exceeding the amounts available. If you're keeping track, we now have 5 events that constitute violations of the Anti-Deficiency Act. Spending more than Congress appropriates, spending money before Congress appropriates it, spending more than your apportionment, spending more than your allotment, and accepting unauthorized voluntary service. We've covered 6 rules for spending federal money. How can we make sure we're following those rules? That brings us to rule number 7, documentation. Rule 7, properly document how the money is spent. When you obligate funds, you must be able to prove that the obligation is valid. We already know that to be valid, an obligation must follow rules 2 through 6, thereby meeting the basic principles of purpose, amount, timing, bona fide need, and not exceed available resources. Given this, we now need to explore the requirements for documenting these obligations. Not surprisingly, Congress passed a law about this too. In the Supplemental Appropriation Act of 1955, codified at Section 1501 of Title 31 U.S. Code, Congress established the documentary evidence requirement for government obligations. Let's take a closer look. Note the opening statement. An amount shall be recorded as an obligation only when supported by documentary evidence. There are two very important points to be made here. We have to have documentary evidence before we can record an obligation. And once we have this documentary evidence, we have to record an obligation. This means we cannot simply record an obligation on the expectation something will happen, like a contract will be signed or an order will be placed. The event has to occur first. Then the obligation is recorded. This also means that if we have met the condition of documentary evidence, for example, signed a contract, we must record the obligation, even if we subsequently discover that there are not sufficient funds to cover it. Needless to say, the requirement for proper documentation is a very important rule in spending federal dollars. Note that some of the documentation requirements incorporate our rules regarding purpose, amount, and time. A binding agreement that is in writing for a purpose authorized by law. Executed before the end of the period of availability. A loan agreement showing the amount and terms of repayment. So, what are some examples of documentation? A signed contract, payroll system time records, travel orders, purchase order, printing order, notice of grant award, and so on. Proper documentation also includes accounting information so that the obligation can be properly assigned to available funding. Accounting information includes the fiscal year of transaction, the appropriation account, the availability of funds, whether they're 1 year, multi-year, or no year, organization, the budget activity, the type of obligation. We call this an object class, like pay or grants or contracts, etc. And the type of transaction, like appropriation or an obligation or a payment. It should be noted that all these requirements exist whether the obligation is a new one or an adjustment of a previous obligation. It is only by proper documentation that one can ensure all the rules concerning purpose, amount, timing, bona fide need, and fund control are being followed. Rule number 8, use an accounting system to make sure you're following the rules. This may seem like an obvious rule, but as we've noted before, Congress has passed a lot of obvious rules. Remember Section 1514 of Title 31 of the U.S. Code? That's the section of the Anti-Deficiency Act that requires that agencies have a system of administrative control that will limit obligation to amounts apportioned and fix responsibility for any over obligations. In addition, in Section 3512 of Title 31 of the U.S. Code, Congress requires that accounting systems, among other things, provide complete disclosure of the financial results of agency programs, provide management information used to run the agency, provide accounting information in support of annual budget submissions to Congress, provide the basis for controlling funds, and provide the basis for integrating with Treasury reporting requirements. And what does all this mean to you? Well, the accounting system is there to restrict obligations to the amount of apportionments and for controlling the carrying out of the agency budget. In other words, to keep you out of trouble. In order for this to be successful, it's important that all transactions be properly recorded in the accounting system. Available funds must be properly entered into the accounting system and distributed in accordance with the apportionment through the allotments and allowances, and each obligating event, whether it's a contract signing or a grant awarding or whatever, must be properly entered into the accounting system. The only way it can keep you out of trouble is for you to ensure the information going into it is correct. So what kind of trouble are we trying to avoid? What happens if you don't follow the rules? Okay, let's summarize what constitutes a violation of the Anti-Deficiency Act. Spending, that is, obligating or expending funds in excess of an appropriation, before an appropriation is made, in excess of an apportionment, in excess of an allotment, or accepting voluntary services without proper authority. You may recall from rule number 3 that Congress amended the original 1870 Anti-Deficiency Act in 1905 to add civil and criminal penalties if it was violated. The original criminal penalties, which were for intentional violations, were a fine of no more than $100 or up to 1 month in jail, or both. And in 1950, Congress increased the criminal penalties to a fine of no more than $5,000 or up to 2 years in jail, or both. Here we can see the adverse personnel actions codified in Title 31. Suspension from duty without pay, or removal from office. And here we can see the criminal penalties for intentional violations codified in Title 31. Put simply, it's a real pain to violate the Anti-Deficiency Act. Even if you don't lose your job, pay a fine, or go to jail, the law still requires you to report the violation. The violation report has to be prepared by the offending agency and sent by the head of the agency through OMB to the president. At the same time, a copy has to be forwarded to the Speaker of the House and the President pro tem of the Senate and the Comptroller General. Section 145.7 of OMB Circular A11 requires that this report contain the title and tafs of the appropriation or fund account, the amount involved for each violation, and the date on which the violation occurred, and position of the officers or employees responsible for the violation. All facts pertaining to the violation, including the type of violation, the primary reason or cause, any extenuating circumstances, and any germane report by the agency's Inspector General. A statement of the administrative discipline imposed and any further actions taken with respect to the officer or employees involved in the violation. In the case where an officer or employee is suspected of willfully and knowingly violating the Anti-Deficiency Act, confirm that all information has been submitted to the Department of Justice for determination of whether further action is needed. A statement regarding the adequacy of the system of administrative control prescribed by the head of the agency and approved by OMB. Statement of any additional action taken by or at the direction of the head of the agency, including any new safeguards provided to prevent recurrence of the same type of violation. Okay, let's review the 8 rules for spending federal money by organizing them in a chart. First, rule number 1, Congress makes the rules. This rule is actually a rule about the rules, so we'll place it at the top of the chart. This rule reminds us that the Constitution gives Congress the power of the purse. If Congress didn't give you permission to spend funds, then you shouldn't spend the funds. Rules 2 through 5 are what I would call the core rules. Rule number 2, spend only for purposes authorized by Congress. Based on the 1809 Purpose Statute, and given that Congress has the power of the purse, we can only spend funds for the purposes Congress has established. You should carefully read appropriating language and any referenced authorizing language, keeping an eye out for earmarks or any terms and conditions for the use of the funds in appropriation language or general provisions. Acquaint yourself with the legislative history of an appropriation, especially any detailed guidance Congress may have communicated through committee reports and tables. Even though broad purposes may be clear from authorizing and appropriating language, specific purposes like whether funds may be used for administrative costs or to buy food or personal items may still be difficult to determine. Pay attention to prohibitions in general provisions like fetal tissue research or pay caps. Always consult with your general counsel if you have any doubt about what you're purchasing or asking to be purchased with federal dollars. Purpose is a key element of appropriations law. Rule number 3, don't spend more than Congress appropriates, and don't spend money before Congress appropriates it. This prohibition, which formed the original corpus of what has come to be known as the Anti-Deficiency Act, has been around since 1870. Congress felt so strongly about this that they established penalties in 1905 and updated them in 1950, making a violation punishable by a fine and/or jail. Included in this admonition is the impermissible augmentation of funding from sources other than those authorized by Congress, as well as the acceptance of voluntary services without authority. Amount is a key principle of appropriations law. Rule number 4, spend the money only during the time period provided. Given their power of the purse, Congress also establishes timing or period of availability for spending appropriations. The timing may either be 1 year, annual, more than 1 year, but limited, multi-year, or without limit, no year. Treasury assigns accounts called Treasury Appropriation Fund Symbols, or TAFs, to enforce these time periods. Time is a key principle of appropriations law. Rule number 5, spend the money only for bona fide needs of the time period provided. Congress further tightened up the time rule with the Bonafide needs rule. This rule, which is as old as the original Anti-Deficiency Act, requires funds to be used for expenses properly incurred during the period of availability. One cannot use current year money for last year's or next year's expenses. Determining bona fide need can be a complex undertaking, especially in the contract world, where one needs to determine whether a contract is for a severable or a non-severable service. Remember that you cannot incrementally fund a non-severable contract or forward fund severable services contracts. It's very important to charge obligations to the appropriate fiscal year. In all these cases, contract staffs need to be very careful and consult with the Office of General Counsel as needed. Bona fide need is a key principle of appropriations law. Rules 2 through 5 compose the core principles of appropriations law. The last three rules, 6, 7, and 8, are what I call the implementing rules. These are the rules that require us and help us comply with the core rules. Rule number 6, make the money last until the next appropriation. Congress requires OMB to apportion funds in order to ensure that agencies don't run out of money before the period of availability ends. Spending must not exceed the apportionment or a violation of the Anti-Deficiency Act is incurred. Based on required agency fund regulations, allotments are issued to enforce the allocations of the apportionment. Spending must not exceed the allotment or a violation of the Anti-Deficiency Act is incurred. Allowances are then issued based on the allocations of the allotment. Funds may only be obligated after all these control steps are taken. Because this process of administrative control of funds is by Treasury account, it ensures that funds are properly obligated within the general purposes and amounts appropriated. Having a control system is the first rule of implementation. The next rule, rule number 7, is properly document how the money is spent. Be sure and properly document your obligations. The 1955 Supplemental Appropriations Act includes requirements for the proper documentary evidence for recording obligations. Examples of proper documentary evidence include properly executed contracts, purchase orders, notice of grant awards, etc. And proper documentation also includes accounting information. Finally, in order to implement fund control documentation rules, we need rule number 8. Use an accounting system to make sure you're following the rules. Congress established a rule requiring agencies to have accounting systems that help agencies follow all the other rules for spending federal money. By limiting obligations to amounts apportioned, fixing responsibility for any over-obligation, integrating with Treasury, and keeping track of account balances, these rules and requirements exist to help agencies stay out of trouble. These 8 rules are intended to provide a very basic understanding of the principles of appropriations law. Remember that appropriations law is not static. It's constantly updated with new opinions. If a specific question arises, it's always a good idea to consult your Office of General Counsel.
Thanks for listening.